Yes, Ms. Page.
My Lords, in answer to Lord Sumption earlier, I spoke about the presumption of damage, and I think the best way in which I can put it is that the presumption of damage stands in place of proof. It is the proof. That is, in fact, how it was put in one of the early authorities, Thomas Starkey, that we refer to in our case. So if you prove publication and you meet the objective test of defamatory, your cause of action is complete. But there are two important control mechanisms. The first is that even if you have suffered a brick through the window, if the words do not meet the objective test for defamatory, you have no cause of action. This isn't an action on the case for damage. This is for injury to reputation. And if the ordinary, reasonable, fair-minded representative of right-thinking society would not think the worse of you for it, then no matter how many bricks you have through the window, following the article, you do not have a cause of action. So that's the first control mechanism, and that is at the front point, at the point where the cause of action is composed. And the position at the time of the Act is that Thornton was the contours of that part. Then you have the Jamil jurisdiction. So the Jamil jurisdiction presupposes that you have a cause of action according to the Thornton, or we say now the Thornton plus test. So you've got through the exercise, you got over the hurdle of showing that what has been published about you, and it includes the circumstances of publication, so if it was a joke or if it was irony or satire or whatever, that may mean you don't get over it. It's not just literally the words, it is also the circumstances of publication. But if you get over that, and the circumstances of publication are such that the judge applying these rules has concluded you have a cause of action in defamation, that cause of action can be stopped by the court any time down the line. Even at trial, you can take a Jamil abuse point. More often it is taken before trial. It can be taken before service of defence, after service of defence, after witness statements or disclosure, before at trial. And that is the safety valve, that is the pressure safety valve in which the court at that point will examine all the circumstances that Mr. Price wants to push into the front load into the actionability test, to push it into Thornton. All the circumstances can be looked at, but it is upon the application of the defendant. And of course, the advantage to defendants, if Mr. Price's argument is correct, is that the burden of proof will be reversed. At the moment, the burden of proof for Jamil abuse, the courts have decided, should rest on the defendant, who seeks to show, and it is not merely looking at, has there been actual injury to reputation? It is also looking to see whether, even if there's been no actual injury to reputation, there is a need for vindication. There's a need for there to be a court finding in favour of the claimant as to the absence of truth or other justification for the publication, and a sum of damages which nails the lie or marks the gravity and the falsity of what's been published, which you carry through with you in life as something you can wave at people if at some point somebody's, oh yeah, I remember you were the person who beat up your wife. I remember reading about that case, then read about your wife later, and I remembered that you were the one who beat her up. That is why you need to get to court. And on a Jamil application, the court is looking at that as well. It is also looking at whether or not there has been injury to feelings that should be compensated. So you can have a situation in which there has been a highly defamatory publication 1 week, 2 weeks later, there has been a fulsome apology and withdrawal, and the court could say, well, actually, that effectively undid the harm to reputation, because no one now be in any doubt that it's been fully withdrawn by the defendant. But in the meantime, you may have suffered horribly, and that you are entitled to compensation for that, and it is not parasitic upon proving any actual harm to reputation. There is also the need for an injunction against further repetition. So if the analysis from Mr. Price is correct, it means that a newspaper can, with impunity, publish defamatory falsehoods about an individual and carry on doing so, and there is no redress for that unless you get the brick through the window. I just use the brick through the window as a simple example, but you get something out of the footnote 27 type, which tells you, one would have thought, nothing that you don't know from actually looking at the words, their meaning, and the circumstances of publication.
If you fail to get an injunction on whatever ground and the libel is repeated, your damages are going to be that much greater.
Yes, they are.
So your reference to this happening with impunity isn't quite right.
Well, it can happen with impunity if you can never prove the harm, you can never bring the action. It can be repeated by everybody. It just becomes a free-for-all. That isn't protection of reputation. There are also, as I will show you when we go through the Act, there are two new, very important remedies available to a claimant, but he cannot go to court and get those remedies unless he succeeds on liability. So he has to have a cause of action, otherwise he simply can't get them. Now, I want to go to section 1 and the words, but just one sentence before that, it's been suggested, certainly by the Media Lawyers Association, that the law as interpreted by the Court of Appeal has chilled. There is no evidence of that. The court cannot just take that sort of assertion and decide what the law means. And there is no evidence that trivial claims have been allowed to proceed. We have hugely experienced defamation judges who are steeped in it and know perfectly well what it is that Parliament intended to do. So can we now go to section 1 itself and go through that and the Act? And we have that in the first volume of the Joint Authorities, and it's the first tab. Now, starting with the actual wording of section 1.1 and taking it bit by bit, a statement, now we know that is a means of conveying meaning. In the 1952 Act, it used the word words, and I frequently use the word words or a statement or a gesture or anything that can convey meaning. So it's not quite right when Mr. Price says that means the article. No, it doesn't. It means the words complained of. And it means their publication to each individual to whom they are published. So a statement or the words statement is not defamatory. Defamatory is a well-established common law term, and it is a term that's about gauging the tendency of the words, their capacity to cause serious harm, I would say it would now be serious harm to reputation. It is looking at the quality of the words. That is what defamatory means and has always meant. Unless its publication defined in section 15 is the conveyance of it to, or its defamatory meaning to another individual. So when Mr. Price refers to the press is rolling. It is not the press is rolling, it is someone reading the words. So unless its publication, and now I'm going to read it first without is likely to, unless its publication has caused serious harm to the reputation of the claimant. That, first of all, of course, presupposes that there has been a publication has taken place. So all the ingredients of the cause of action are there, subject to it being defamatory. Has caused serious harm to the reputation of the claimant. Harm, the point at which harm is caused, is the point when the meaning is conveyed to the mind of the reader. That is the point. So it's not when the presses roll, it's not when the article's put online, it's not when the brick comes through the window, it's when the mind of the person who's reading it has his attitude towards or opinion of the claimant changed to a seriously harmful extent. And whether it's harm or serious harm, it is the point of reading or the point of conveyance or the point of watching on the television. If one then goes back, and reputation, we know what reputation is, it's the estimation of people. It's not whether you kept your job or not kept your job, or whether someone's not invited you. It is the estimation in which you are held, and it is also an important part of your self-esteem, your human dignity, your ability to make relations with other people, which is why it is now recognized as a protected right under Article 8, and Article 10 no longer is seen as having presumptive priority over it. Now, then is likely to cause, if we reread without the has caused in it, a statement is not defamatory unless its publication is likely to cause serious harm. Now, unless its publication is likely to cause serious harm is neutral as to whether it's a transmission of the statement to someone that's already taken place or one that might take place in the future. The words its publication are, but when you say its publication is likely to cause serious harm, you can only be referring to a piece of harm in the future, which means a publication in the future. And that means a publication of these defamatory words. So this is why we say that it isn't an alternative way of trying to establish a cause of action where you have to worry about, are you looking forward at the date of the claim form or the date of determination or any other arbitrary date. You are looking ahead to a publication where you have issued a claim form or you intend to issue a claim form in relation to a publication that is likely to cause you serious harm because it is defamatory on its face and it is likely it is going to be published. And we say, therefore, this is simply bringing in the Cream and Banerjee test for likelihood. It is more likely than not, because it is talking about whether you have a cause of action quia timid.
But your submission is that it is likely to cause part of this subsection denotes a future publication. It can't apply to a past publication.
Exactly. They're looking at both. So you can look at to see whether a statement is defamatory after it's been published. Go to your legal advisor and say, they've said this about me on the front page of the Evening Standard, and he said, oh, it's defamatory of you. He has the phone call on Friday night saying, we are planning, the Evening Standard, to publish this about you on Sunday. He goes to his lawyer and he says, it's defamatory of you. And it is likely to cause you serious harm, therefore. It has caused you serious harm because they published it last night and it's seriously defamatory of you. You have been caused serious harm to reputation. Okay, they haven't published it yet. They're going to publish it next week. that is likely to cause you serious harm because on its face it is defamatory. So whether it was necessary to put is likely to cause in order for one to have the ability to go to court quia timid is not the point. It may well be without it. You would have been able to say, well, okay, so I haven't actually been caused serious harm to reputation yet because there's been no publication. Nonetheless, you should stop them doing something that will be a wrong if they do publish. But Parliament...
It's just that the way that the subsection reads, a statement is not defamatory unless its publication has caused or is likely to cause. At first blush, one would have thought that that could apply to a statement which has already been published but is perceived to be likely to cause serious harm.
It wouldn't. It would be if it caused serious harm after publication. It is because there has been a fresh reader of it or a republication of it, and that gives rise to a fresh cause of action. So this has to be, therefore, we say, well, there are two possibilities. We say this is the quia timid. The other possibility is the possibility that we saw highlighted, if I can find the reference in our case, to a case of McLaughlin in which Mr. Justice Tugendhat was asked to strike out a case because there was no no reason to think there had been any actual harm. It's paragraph 39, I'm told by Mr. Basutil, of our electronic bundle 108, hard copy core bundle 106. And we accept the possibility, the fallback possibility, that this may be what Parliament had in mind. And what he said in that case was that it's true that the number of addressees of the emails complained of is small, but they are all persons who have been concerned with education at the school, words complained of in electronic form. They may be stored indefinitely and easily searched and republished, both generally to those concerned with education and in particular to others in the Department for Education or in the first defendant. The damage so far suffered by the claimants may be small. I express no view on that, but simply assume that counsel may be right so to submit. But the main point of defamation proceedings is vindication. Vindication includes preventing or reducing the risk of future publications of the words complained of. The fact that the damage so far may be small, if it is no indication of the extent of the damage which is prevented from occurring in the future when a claimant in a libel action obtains a public retraction or a judgment in his favour. So it may be that is what Parliament is looking to. But it is nonetheless, it is looking to further publication, because harm is what occurs upon publication.
One alternative way of looking at it is that it is simply referring to the fact that when a court comes to assess damages, whether general or special, it looks at the totality of the damage, including any prospective further damage that may arise from the existing publication. It seems to me that the way that the section is phrased is equally consistent with that interpretation as with the one that you have been putting forward.
Maybe. However, this isn't, or is assumed to be about actionability rather than approach to damages. The common law has got a very, very developed approach to damages. But what this, we say, does not do is alter what creates the cause of action. This is what we're particularly concerned about. We have to know when the cause of action is complete. Can't have a situation where you can't, when you have been the subject of a defamatory, a seriously damaging allegation published particularly to the world at large, you've got to know whether you've got a cause of action or not. And either Parliament has now decided that it will no longer be actionable per se, and I'll come back to that in a moment, or it has not done anything to alter the fact that it is actionable per se, in which case the only question is what are the ingredients of the cause of action? Has anything changed? And we say only one thing has changed, which is that, as Lord Justice McFarlane put it in the Court of Appeal, the water table has risen, therefore the level at which the threshold you have to get over in order to establish that something is actionable as defamatory has gone up. And similarly, the floor for Jameel abuse has gone down. Jameel abuse will be easier, actionability harder. But those two, that remains the structure.
Am I summarising your position correctly if I say, if you look at the words in subsection 1 in isolation, then the words, the publication is likely to cause serious harm to the reputation in the future, might be consistent with a past publication causing serious harm. But unless in this section Parliament has chosen to abolish actionability per se, then that cannot be the meaning. And you say actionability per se has not been abolished because look, for example, at section 14. Yes. Is that a fair summary?
That's absolutely right, yes. If we then go to the explanatory notes, the relevant part of the commentary is electronic 523, part 21. Paragraph 10 says that a statement is not defamatory unless it's published has cause or is likely to cause. That's the wording of the statute. The provision extends to situations where publication is likely to cause serious harm in order to cover situations where the harm has not yet occurred at the time the action is commenced. Well, that, we say, publication is neutral as to when in time we're talking about, but likely to cause serious harm must be a reference to a publication to someone of defamatory words. There's nothing here to tell us that the structure has changed. And of course in section 1.2, and I should add that section 1.2, if it's something that your lordships will want to look at, Mr. Basutil is ready to talk about section 1.2 compatibly with our construction of section 1.1. Section 1.2 does distinguish between harm to reputation and the consequence of the harm, because the harm has to have caused serious financial loss. The financial loss is not the harm, it is something distinct from the harm. Then going back to section 11 of paragraph 11 of the explanatory notes, the section builds on, and I emphasize the word builds on, the consideration given by the courts in a series of cases to the question of what is sufficient to establish that a statement is defamatory. A recent example is Thornton, in which the decision of the House of Lords Simon-Stretch identified as authority for the existence of a threshold of seriousness in what is defamatory. Now, pausing there, it's not dismantling Thornton, it is building on Thornton. And Thornton is part of the common law structure to determine actionability subject to Jameel, which we come on to in the note in a moment. But the threshold of seriousness, which is not being expressed to be in any way being abolished or overridden, is a common law concept. It is what was recognised by Mr. Justice Tugendhat in Thornton. So when we talk about the threshold of seriousness, we are talking about something that has a well-known meaning at common law. The note goes on, there is also currently, so anyone reading this act today, next year, 5 years' time, will know that there is also currently potential for trivial cases to be struck out on the basis that they are an abuse of process because so little is at stake. Not because there isn't a cause of action, but because, as it was put in Jamil, the game is not worth the candle, or the game is not worth even the wick. And it goes on to say, in Jamil endowed judgment, to establish that there needs to be a real and substantial tort. Not that it has to be established there has been a tort, but that the tort that is actionable in a technical sense is real and substantial. And then the sentence that was added at the same time as the government removed substantial and put in serious, the section raises the bar for bringing a claim, so that only cases involving serious harm to the claimant's reputation can be brought. So what is the bar? The bar is the threshold of seriousness in Thornton. There is no other bar. Jamil doesn't establish a bar. Jamil says nothing about actionability, says nothing about the cause of action. On the contrary, Jamil is the case in which the presumption of damage, the irrebuttable presumption of damage, standing in place of proof of any actual harm, was challenged as incompatible with Article 10, and it is resoundingly upheld as compatible with Article 10 and as performing a function of value. And one of the reasons, not necessarily the most important reasons, because the most important reason is difficulty of showing damage, but one of the reasons is that they express the disapproval, the idea that readers should be called to say whether they thought the worse of someone or what they thought the worse. That has never been admissible. That only admissible on damage is never admissible on deciding whether words are defamatory. So then in paragraph 12, subsection 2 reflects the fact that bodies trading for profit are already prevented from claiming damages for certain types of harm, such as injury to feelings, and are in practice likely to have to show actual or likely financial loss. The requirement this be serious is consistent with the new serious harm test. So in other words, this reflects the common law, still actionability per se, because at common law, the likelihood, you have to have been the subject of words that hit a company in their pocket in some form or other. So there's nothing controversial about that. Now, that is what I say about the wording of section 1. There's nothing here to indicate that the common law methodology has been abolished. The only message you can get is that the common law methodology has been stiffened. It is only about limiting trivial claims. It is perfectly apt, as it stands, using the common law methodology to operate correctly in the hands of highly experienced judges. One does not need to complicate matters by importing into actionability all the considerations that might be relevant to whether or not it is an abuse to pursue the cause of action to trial, or whether at trial you may establish little in the way of actual injury, but you are you therefore justified in feeling distressed, and how much vindication do you actually need? All that goes into the mix at trial, as it does on a Jamil abuse. Mr. Price's argument appears to impute to Parliament that it wanted actual proof in place of presumption on the premise that the common law methodology is not a reliable means from which to conclude that serious harm will be caused. So, notwithstanding that it's extremely grave allegation, notwithstanding that it's been published to someone, 10 people, 1 million people, you have to look at each one separately, notwithstanding the fact that it's obvious that somebody is going to think, wow, the fact they didn't act on it, the fact they didn't believe it, this somehow is being put forward as a more reliable test, which you should read into as Section 1 as being the intention of Parliament. Well, that I submit is utterly fanciful to think that the methodology that is being proposed by the appellants is in any sense capable of improving upon the common law. He criticises the common law methodology for deciding defamatory as an exercise in the abstract. We submit that is absolutely the right way to do it. He submits that he imputes to Parliament wanting to do away with the repetition rule. However, two things about the repetition rule. First of all, if we go to the explanatory notes, paragraph 15, we see that actually Parliament intended the repetition rule to carry on. This is in relation to the defence of truth, which actually I need to come back to on another point. There's a long-standing common law rule. There's no defence to an action for defamation for the defendant to prove that he or she was only repeating what someone else had said, known as the repetition rule. Subsection 1 focuses on the imputation by the statement in order to incorporate this rule. The other point about repetition is if we go to paragraph 15 of the Act. Paragraph 15. Paragraph 7. Paragraph 7 contains various...
Paragraph 7 of which?
Oh, sorry, paragraph 7 of the 2013 Act, page 513, section 7.
Section
Sorry.
7.
Did I say paragraph 7? Sorry, section 7. One doesn't need to look at it just to understand that what this is are extensions to the reporting privilege that started off in the common law reporting privileges. It was then extended into the 1952 Act, further extended in the 1996 Act, further extended in the 2013 Act. And what the privilege does is allow you to report somebody else's statements without suffering the repetition rule. It gives you a privilege to report. It disapplies the repetition rule for those categories of publication which are protected. So the repetition rule its existence and its operation and its correctness is the premise of the, continues to be the premise of the Act. I said there was a further point I wanted to make in relation to Section 2 of the Act, which is the truth defence, because we get the word serious, we get the concept of serious harm again. We've got this at 509 of the electronic bundle. So this is a wholesale lifting into statute of the common law defence of justifications. Defence to an action for defamation to show the imputation conveyed by the statement complained of is substantially true. Of course, the imputation is arrived at by the common law objective methodology. Subsection 3 applies in an action for defamation if the statement complained of conveys two or more distinct imputations. And 3 says, if one or more of the imputations is not shown to be substantially true, the defence under this section does not fail if, having regard to the imputations which are shown to be substantially true, the imputations which are not shown to be substantially true do not seriously harm the claimant's reputation, have not seriously harmed the claimant's reputation. This would only ever be at trial. It is tense neutral, and it is saying this would be a trial following a defence of truth that's only partially successful, and the exercise the court would be doing is looking at the harmfulness of the imputation not shown to be true and comparing it with the injurious quality of those which have been shown to be true. And if it concludes that there is not that what is left unproven is not seriously harmful, and it must be the quality of the words, then a defence is established. And if the position at trial was that the claim that the defendant failed to prove as true an imputation that the court would not consider seriously harmful relative to the imputation proved to be true, it doesn't matter what consequences flow, because this is looking at the injurious quality of the imputations, one relative to the other. They are not looking at actual consequences. And there's no way, how could you? If you have an article, a lot of articles may have a whole raft of allegations about someone, and the idea that one can separate out where the Twitter storm, whether the Twitter storm was caused by this imputation or that imputation or whatever. It's an absurd exercise to think that that is what should be done.
So what are you saying is the significance of the fact that in subsection 3 it says do not seriously harm rather than have not seriously harmed?
The significance is that it is not looking back. It is not saying have they caused serious harm. It is plainly looking at their tendency.
But that's a judgment that has to be made at the time that the imputations are being considered. And surely those could be imputations which existed before that judgment is made.
Yes, and that has been done by the exercise that on the appellant's idea of how the law should be applied would be completely irrelevant. You'd just look to see whether there'd been damage. But what's the point of going through the whole exercise of deciding what is the meaning of the words, what are the various imputations, are they defamatory?
Surely the point is, on the appellant's case, is that if a series of imputations are alleged, those which occupy the serious category are shown to be substantially true. There are imputations remaining. If they are not shown to be substantially true, they fail if no serious harm can be attributed to them.
Yes, but the Section 1 is about a statement. It's not about individual imputations. The court is looking at the words complained of, which may contain various imputations.
Does the fact that cause appears twice in section 1.1 and not at all in 2.3 matter, or is that just an accident of drafting?
We suggest that it points to the fact that serious harm is not about what has been caused other than the publication of the words that qualify as defamatory. It's not saying at trial, it is not that the court has to say the imputations which are not shown to be substantially true have not caused serious harm to the claimant's reputation. It doesn't have to look at that. This is an exercise, and it was an exercise that was done under the 1952 Act in Section 5, which is in materially the same terms. It was an exercise of looking at the tendency of the words, looking at their defamatory quality, not looking at whether they had produced consequences. And we must keep in mind constantly that harm and consequences, things that may happen after, are two distinct things. The harm is the conveying of the message into the mind of somebody. The consequences are what he then does with it.
But if the untrue imputations have caused serious harm to reputation, Why should there be a defence?
Well, that is just that is what Parliament decided in 1952 in Section 5, and that's what they've decided.
Oh, so this repeats.
It's a replication. It's
see.
intended to replicate
I see.
the position.
So if there's a
before.
bit of a mismatch between Section 1 and Section 3(2) of a temporal character, it may be they've just carried, they can be excused to some extent because they've just carried something forward from 1952.
We submit that the temporal difference is not a difference in terms of what the court is looking for. In all cases, the court is looking at the tendency of words to cause serious harm. It's doing that in Section 1, it's doing that in Section 2.3. And Section 2.3, if we can just go 2 tabs down to the 1952 Act, it's same bundle, page 540 electronically, 38 on paper. Section 5, in an action for libel or slander, in respect of words containing 2 or more distinct charges against the plaintiff, a defence of justification shall not fail by reason only that the truth of every charge is not proved. If the words not proved to be true do not materially injure the plaintiff's reputation having regard to the truth of the remaining charges. And the explanatory notes of the 2013 Act say it was intended to replicate this.
Oh,
and
thank you.
And in Section 5, the operation of Section 5 at trial, and it did arise from time to time in cases, was that the court would be looking at the relative injurious quality, the relative harmfulness in the abstract of the various imputations, never looking to see whether actual harm from one imputation rather than another would have been wholly inadmissible on the question of whether or not Section 5 defence applied. And it was a defence to liberalise freedom of speech and ease up defences of justification and truth. And the passage in the explanatory notes that confirms it's reproducing it is paragraph 17. It's electronic page 524, hard copy 22. It explains what it is, and then the last 2 sentences in paragraph 17. These provisions are intended to have the same effect as those in Section 5 of the 1952 Act, but are expressed in more modern terminology. The phrase materially injure, used in the 1952 Act, is replaced by seriously harm to ensure consistency with the test in Section 1 of the Act. But no suggestion that the methodology has changed, only that the burden has changed, that the more readily might a Section 5 defence now...
Well, I think the standard rather than the burden. The standard.
Yes, the standard, sorry, yes, that's correct. Okay, well, Section 8, I think... Oh, no, but before that, can I just... Well, before we leave Section 2, just draw attention to the fact that in Section 2.4, there is an express abolition of the common law. So it took the common law, replicated it in a language that it liked, and then struck a line through the common law. In the honest opinion defence in Section 3, apart from one adjustment, namely whether or not a comment has to be on a matter of public interest, apart from one adjustment, material adjustment, that is the defence affair comment brought in and put into words that Parliament approves, and in Section 3.8, again, they say put a line through the common law. The common law defence is abolished. That is not a rejection. on the contrary, common law defence has been approved. Section 4 is exactly the same. Section 4 is intended to, as the explanatory notes say, it's intended to replicate Reynolds and the cases that followed, including flood in this court, and it is replicated in substance in Section 4, and again in 4.6, they say put a line through the common law defence of Reynolds. So now you look to the Act. The next one I'd like to invite you to go to is Section 8, which is the so-called single publication rule. And as my Lord Briggs pointed out this morning, the premise of this section is that the cause of action accrues upon publication. Now, that would be an extraordinary premise for it to make if actionability per se was at the same time being abolished. And the single publication rule is only a deeming provision. It doesn't alter the fact that every reader, every time someone reads the newspaper article, whatever it is, there is a fresh cause of action. It just caps the point at which you can't start an action. And it does that because it is regarded by the media as untenable to have a situation where once they have archived something, somebody could come along years later and say, I have a cause of action. And the famous case that this was directed at abolishing was the Duke of Brunswick and Harmer. It's referred to by the Court of Appeal in the Jameel abuse case. And Lord Phillips said in that case, in the judgment of the court, that nowadays that situation would be met with an abuse application. It'd be struck out. It'd be correct that it'd be a cause of action. So this is dealing with that, and there's an important history not to overlook about the 1 year limitation period, because the 1 year limitation period is uniquely short for a tort. The answer of Mr. Price is to say, we just use the general discretion under Section 32A. Well, as Lord Justice Davies said, that will not do. And that is a separate matter I want to digress onto.
Some of us, but only some of us, spent all day yesterday looking at that very provision in a Privy Council context.
Oh, yes, I don't know if it's in the same terms in the Isle of...
It is in the same terms, it's a different section number. Yes.
Right. Well, the first thing I wanted to draw attention to is it's in our pink respondents bundle. Electronically, it's page 1945. And this is the recommendation of the committee chaired by Sir Brian Neal as to why Parliament should reduce the limitation period to 1 year, which they did in the 1996 Act. I just wanted to invite attention to page 1949 electronically, page 107, I think.
Which tab?
It's the pink bundle, which I think should have electronic numbers. Sorry, should have electronic numbers on it.
So give me the electronic number again.
It's tab 9, 1949.
Okay.
And this is Sir Brian Neal in July 1991, a committee which included Lady Justice Sharp, as she then was not.
It's actually 105 in the supplementary electronic bundle.
That's where it starts, and it's 107 of the hard copy. It's paragraph 8 on delimitation. We've canvassed opinion and found a wide measure of agreement, not surprisingly, among media representatives that the same reasoning would justify an even shorter period. Memories fade, journalists and their sources scatter and become not infrequently untraceable. Notes and other records are retained only for short periods, not least because of limitations on storage. In the nature of things, we had no countervailing representations from plaintiffs seeking to uphold the 3-year period. In our experience, it would only be in the most exceptional cases that a plaintiff could be justified in delaying for more than a year before starting his proceedings. And then they say, obviously, if he didn't know about the publication.
I'm so sorry, could you give me the supplemental bundle electronic number?
Say
I'm so sorry.
110.
110, thank you.
1949 to 1950.
Thank you.
Now that, so the so-called general discretion, as it's put, and perfectly correctly, was considered in 2014 by the Court of Appeal in the case we have at tab 6 of the same bundle, which is electronic 1903, hard copy 61.
Yeah, unfortunately, the numbering of this supplementary bundle doesn't continue from the... Not to worry. Which tab is it?
Sorry, it's tab 6.
Tab 6.
We thought it did.
Well, it doesn't. I'm not on the electronic version,
No,
unfortunately.
sadly it doesn't.
Exact reverse of the problem with the last one.
It's the hard copy does.
The antediluvian print readers have got the MS numbers, but the electronic readers haven't. And serve them right.
One doesn't need to know.
A rare victory for the antediluvians.
One doesn't need to know anything about the facts. It was an application to disapply the limitation period, and one only needs the first holding. And the reason I mentioned with Justice Sharp is that, as well as being on the Neil Committee, she was the
I'm
judge.
very, where are we now?
64.
Thank you.
So sorry. Tab 6.
Yeah.
The holding on the second page of the report.
Yeah.
Held allowing the appeal that although the discretion to disapply the limitation period is wide, special considerations applied to the exercise of that discretion in libel actions, that since the purpose of a libel action was to vindicate the claimant's reputation, swift remedial action was needed, requiring the action to be heard as soon as possible and the claim to be pursued with vigour. And so disapplication of the limitation period in libel cases was exceptional. But given the policy reasons underlying the 1-year limitation period for libel claims, ignorance of limitation period rarely, and so on. Now, before we put that bundle away, under those of you who were entertained by Section 32A yesterday will recall that there are certain factors that have to be taken into consideration. We have got the Limitation Act in the first authorities bundle at tab 5, electronic 589. And it's the relevant section 32A, which was introduced by the 1996 Act, is electronic 592, hard copy 90. And the discretion, which now has to be read as together with Section 8 of the 2013 Act, provides that according to who is prejudiced, how the prejudice falls if it isn't disapplied, the end of the subsection may direct that section shall not apply to the action and shall not apply to any specified cause of action to which the action relates. And then it says that in acting under this section, the court shall have regard to all the circumstances of the case, and in particular to, and obviously, the length and reasons for the delay. And then B, where the reason or one of the reasons for the delay was that all or any of the facts relevant to the cause of action did not become known to the plaintiff until after the end of the period mentioned, the date on which such facts did become known, and the extent. So there, the court is particularly enjoined to look at when the claimant had knowledge of all the facts relevant to the cause of action. And at common law, all the facts relevant to the cause of action are the publication of the defamatory words. Now, in C and Mirror Group, which we have in the pink bundle, tab 7, sorry. The facts, this was in the judgment of Lord Justice Neal. This was a case in which there was an application to disapply under the predecessor of Section 32A, but for all purposes it's materially the same, because the predecessor also required the court to look at...
I'm sorry, I'm afraid I've lost you. Where are you?
So I'm in the pink bundle.
Oh, you're back at the supplementary bundle.
Yes,
I
sorry.
see. That's all right. No.
Page 73 or page 1915.
Yes?
And the key point here is that whether or not you had any... perhaps I should explain what happened, that this was a case in which the plaintiff had taken 2 children out of the country after being granted custody, had the approval of the court, but she didn't return. The husband, after reporting restrictions were lifted, spoke to the press and made seriously defamatory allegations against the mother, allegations which were ultimately held to be not true. They were reported in the Daily Mirror, which did not make it clear that the words attributed to the father had been spoken outside court rather than on an occasion of absolute privilege in the family proceedings. When the plaintiff complained to the Mirror, she was told by the newspaper that they had merely reported what had been said in court. So she obviously couldn't bring a case. At a point after the expiry of the limitation period, she learned that the allegations had not been made in court, and so she started her libel action. An application was made to strike out because it was past the limitation period, and she failed because she knew she had the facts relevant to the cause of action, namely the publication of defamatory material. The fact, anything that contributed towards whether it would succeed or not, was something that did not come into facts relevant to the cause of action. It was the statement of claim test, and the statement of claim test here does not include anything to do with damage. Sorry, at common law, it doesn't include anything to do with damage. So if you are going to have to wait for a piece of damage to materialize, so a consequence, a piece of consequential damage to materialize, and I should perhaps say it's unhelpful in a way for it to be called a piece of serious harm. Really what the appellants are saying is that defamation is now actionable only on proof of special damage. It doesn't matter, special damage can embrace anything where you have to specifically identify it, specifically plead it, and specifically prove it. And that's their case. You've got to identify it, plead it, and prove it. So it's special damage in the ordinary legal sense of that word. So you're advising somebody who's had a serious allegation published about them, and first of all, on the methodology that the appellants seek, you would have to say, well, does it meet the so obviously test? So is it so obviously injurious that you don't have to prove anything? Well, that's a total lottery. There are no rules for that, no rules at all, because we're told that the repetition rule and the reasonable reader rules are not reliable guides and don't assist on the so obviously causative of serious harm. So you don't know whether you've got a cause of action at that point, so you advise the client to go off and talk to his friends, wait and see what happens to his job. And a year after publication, he has perhaps, or at any time, he has lost his job. So you say, well, okay, you've proved your piece of special damage. And so what then happens? This is actionability. The appellants would say, well, that's an excessive response to what was published. That isn't foreseeable. We shouldn't have to shoulder that damage. So that's not damage. So you would never know when the cause of action is complete. I mean, it's a recipe for anything goes and just make it up as you go along. But if the reason why I wanted to refer to C was because it was clear in some of the things that Mr. Price said this morning that he accepts that the serious harm to reputation is what happens when the words are read. He accepts that. But what he is looking for is something to corroborate, some consequence to corroborate the fact that, to prove that the harm that took place when the words were read was serious harm. And for that purpose, he seemed to distinguish between the substantial test under Thornton and the serious test. As I understood him to be saying that the substantial test could be satisfied by looking at the words, but the serious test couldn't be satisfied by looking at the words. Now, if the serious harm in fact occurs upon publication, but you have to prove the adverse consequences, then you are seriously harmed on limitation and under the rule in C, because you have all the facts relevant to the cause of action, because you've got the serious harm, you just haven't got the proof. And until you've got the proof, says Mr. Price, you've got no cause of action. So it's just a recipe for an ill-disciplined attempt to make up a methodology whereby the burden of proof on the claimant is so expanded that he has to prove everything that currently under the common law is the burden of the defendant under Jamil, in a context, as at trial, where the court can look at all the circumstances. So I say Section 32A is not an answer to the supposed injustice. It is an exceptional jurisdiction, and it may be that it would be inaccessible to somebody you would not be able to predict, and it would produce uncertainty and injustice.
Can you think of any other limitation period where time starts to run before you have an accrued cause of action?
Okay, now if we go back to the Act, if we put the pink bundle away, back to the 2013 Act, and now go to Section 12. Sections 12 and 13, just pass over them quickly. These are new remedies that have been granted to claimants. Section 12 is the power of the court to order a summary of its judgment to be published, which of course the purpose of which is to require the defendant to publish the vindication in order that it gets out there. And that requires you to succeed on liability. And of course, you can't succeed on liability unless you have a cause of action. So you can't get the summary of the judgment published that might prevent the harm prevent you losing your job in 5 years' time or your contract not being renewed because you don't have a cause of action because 5 years' time hasn't yet arrived, and so you can't prove your damage. Section 13 is also important. Where a court gives judgment for the claimant, the court may order the operator of a website on which the defamatory statement is posted to remove the statement. So again, another powerful, valuable piece of redress which is only available to someone who has a cause of action. And entirely new, yes. Next we go to section 14, which we have dealt with in some detail in our case. And of course the short point on section 14 is that prior to the 2013 Act, there were 4 common law categories of slander actionable per se, where the presumption of damage provided the proof. No need to prove any actual harm, injury to reputation, anything else. Of those 4, Parliament has decided to take away 2. The Slander of Women Act is repealed. That was one of the statutorily created slanders actionable per se. The publication of a statement that conveys the imputation, and then secondly, the publication of a statement that conveys the imputation of a person's contagious or infectious disease. That too has gone, but the remaining 2 are still actionable without proof of special damage. And if we're right to say that what Mr. Price is saying is you have to prove special damage, that's basically what it amounts to, and that follows from it no longer being actionable per se. It means that one has this total conflict in knowing what to impute to Parliament, to retain actionability per se or not to retain actionability per se.
That means that the special damage has to be serious.
The special damage has to be serious. Well, yes, here it may be, but there are 2 categories that are still actionable without proof of special damage.
It's not just the common law. Doesn't your point go considerably further? Because there's a statutory provision which says in terms that you don't have to prove special damage. And if the common law is abolished, you have a statutory cairn with the mountain having disappeared.
Yes.
Yes.
We have that. Thank you for that.
Yes.
We have that in the Defamation Act 1952,
Precisely.
which is the next, which is tab 3, and it's sections 2 and 3. Parts of the 52 Act were abolished, were repealed in the 2013 Act. Section 2 wasn't, and I also want to say something about Section 3, which is not defamation but malicious falsehood. So there has been left unrepealed the provision that in an action for slander, in respect of words calculated to disparage the plaintiff in any office, profession, calling, trade or business held on or carried on by him at the time of publication, it shall not be necessary to allege or prove special damage.
Which section is that in the 1952 Act?
That is the 1952 Act. I'm so sorry, I mean, this bundle EB...
Yes, we've got the bundle, but which section?
Section 2.
538.
538.
What we have here is the unredacted Act, or the Act as it was passed. Sections 2 and Section 3 were preserved. So,
Is Section 2, as in this original version, is that how it remained in 2013?
yes.
Yes.
So you say that this is still the law?
Still there. So Parliament took away Section 5, which we were looking at earlier. It repealed Section 5 expressly in Section 2.4 of the 2013 Act. But it did not repeal the 1952 Act. And the 1952 Act is what gives actionability per se to slander. And slander has always been treated by the common law as something less injurious to reputation generally, because it's usually much more limited, because it doesn't include broadcasting, that is libel. It's been treated by the common law always as being less injurious than libel. So it would seem, therefore, that we have to impute to Parliament that they intended to preserve actionability per se for a slander of this kind, but if it's libel to this effect, calculated to this effect, because it has the tendency to cause harm, then it would not be actionable without special damage. There's also, I also want to just pass by Section 3.
Just before you do, is damage to reputation special damage or general damage?
No, it's general damage.
Now, Section 1 is all about proving or establishing you've suffered serious harm to reputation. In other words, it appears to be all about general damage.
It is general damage.
Whereas these preservations talk about not needing to prove special damage.
Yes.
Does that cause
Special
any difficulty?
damage, no. Well, special damage is anything whereby someone causes you what's called temporal loss.
Yeah.
It's exactly this.
Essentially,
half of the
pecuniary
examples
loss.
are in footnote 27 of the
Yeah.
case as to what have to be proved for libel. You don't have to prove anything for slander, be anything more than you ever had to prove for libel pre the 2013 Act.
Well, that's to say in the 4 cases at common law.
Yes.
Sorry, I didn't.
When you say you don't have to prove anything in slander, that's the case with the 4 special cases
Yes.
of per se damage.
Yes.
It's not the case generally in slander. Normally, the basic rule is you do. You do have to prove special
Yes,
damage.
yeah, yes,
except
for the
in the 4
exceptions.
cases.
Yes, precisely, yes. Sorry, my hearing is... Now, I wanted to pass by Section 3, because Section 3 is not about defamation.
Just before we get to Section
Yes.
3, I mean, even if there is a distinction between Section 1.1 of the 2013 Act and Section 2 of the 1952 Act, one talking about general, the other talking about special damage, would Section 1.2, where you require to show financial loss, be consistent with the survival of Section 2 of the 1952 Act?
Well, Mr. Basuto's expert on Section 1.2 is right. Section 1.2 does not require you to show special damage. Financial loss is something that can be inferred as part of it's part of the general damages. You can also claim special damage. So
I see.
the sort of prime example of this is Ratcliffe and Evans. That was malicious falsehood. It's a very good case for explaining how actionability per se and the presumption of damage works in defamation. That if something is said about you as a publican that causes customers not to come in, you don't know who they are. You haven't got a claim for special damages.
No.
You've got a claim for general damages. And that is the type of general damage that it is the at-large general damages that are presumed. You don't have, but you can also claim special damage. Section 1.2 does not require you to claim special damage or show any actual pecuniary calculated figure. It requires you to satisfy the court that you will have been hit in your pocket, that you will have suffered serious financial loss, even if you can't say who failed to walk into Marks and Spencer's because there was a food poisoning scare.
In other words, it doesn't have to be computable.
No, it is general damages, as it was in Ratcliffe and Evans, not special damage.
Thank you.
Now, Section 3 is not defamation, it is malicious falsehood. But I draw attention to it because in the hierarchy of actionable torts on words, libel has always been at the top, slander and malicious falsehood have always been lower, and that is why Section 3 was enacted, because it was considered to be unjust in many cases. This is on the recommendation of Lord Porter's committee in 1948. There were cases of injustice because the claimant could prove falsity and malice, but couldn't prove the special damage. But you could infer that from the quality of what was said, you could infer the damaging nature of what was said. You could proceed on the basis of not having to prove special damage. Now, Section 3 could, for a claimant who cannot prove damage on Mr. Price's methodology, a claimant could use Section 3 as a means of at least getting a liability established, providing he can prove malice. Malice, of course, is extremely difficult to prove, or certainly in the case of a newspaper. But if a claimant can prove falsity, can prove malice, he has a good cause of action, whereas in defamation he doesn't. But this doesn't really help him very much, because you can't recover damages for injury to reputation through malicious falsehood. So every avenue for redress for injury to reputation, for vindication damages, for injury to actual injury to reputation, you can only get through that through an action in defamation. You can't get it through malicious falsehood, nor can you get it in any other of the torts. You can't get it through misuse of private information. There is no, that you have to go in via the front door. The explanatory notes on Section 14 at page 532.
Five three three.
532.
532. Yes, I've got it.
Hard copy bundle AP
Yeah.
30. And this is it's exactly as what one's. It's perfectly straightforward as to what it is. It appears to have done is exactly what it says that it has done.
532 paragraph.
Sorry, paragraphs 78 to 80.
Thank you.
I want now to go back to the 1952 Act on a slightly separate point, which goes back to the meaning of defamatory. One of the surviving sections of the 1952 Act is Section 11, which is electronic page number 542, hard copy 40. And this is about stigmatizing agreements to indemnify people who publish libels. An agreement for indemnifying any person against civil liability for libel in respect of the publication of any matter shall not be unlawful unless at the time of publication that person knows that the matter is defamatory and does not reasonably believe there is a good defence to any action brought upon it. So in order to operate that section, you have to know at the time of publication whether something is defamatory, and the court, if it's ruling upon an issue arising out of Section 11, has to be able to conclude whether or not someone knew before any consequences of publication could flow that the words were defamatory. That is only compatible with defamatory retaining its common law meaning of words with the requisite tendency. It cannot possibly sit with an interpretation whereby you impute to Parliament that it's not defamatory until serious harm has been proved as a fact rather than via a legal presumption. We then go to the 1996 Act for a similar point. This is 1996 Act introduced in Section 1, it's page 547, tab 4. It introduced a very important defence on responsibility for publication, again on the recommendation of the Neal Committee, and this is still extant law. And Section 1.1 provides that in defamation proceedings, a person has a defence if he shows, it's his burden of proof, that he was not the author, editor, or publisher of the statement. He took reasonable care in relation to its publication, and he did not know and had no reason to believe that what he did caused or contributed to the publication of a defamatory statement. So again, defamatory here connotes something that at the time of publication, prior to publication, you can assess in the abstract and without reference to or any knowledge of what consequence publication might produce. The next page, we have very important offer of, over the page is a bit more of it. It's subsection 5, page 548. In determining for the purposes of this section whether a person took reasonable care or had reason to believe that what he did caused or contributed to the publication of a defamatory statement, regard shall be had to. And these are all things that pertain to the circumstances of publication, nothing to do with predicting adverse consequences. We then have the offer of amends provisions in the same Act at Electronic Bundle 551, hard copy 49. This was an extraordinarily successful provision fashioned by the Lord Justice Neal's committee, which has resolved countless defamation actions. And this provides that if an offer of amends is made and not withdrawn, and it's not accepted by the claimant, then if the claimant fails to prove malice at trial, then the consequences right. Provision. Yes. Sorry, this is the offer of amends starts at section 2. This is the culmination of it. And it says in subparagraph 3, there is no such defence if the person by whom the offer was made knew or had reason to believe that the statement complained of referred to the aggrieved party or was likely to be understood as referring to him, so it's the objective common law test of reference, and was both false and defamatory of that party. But it shall be presumed until the contrary is shown that he did not know and had no reason to believe that was the case. Again, it is looking at knowledge or reason to believe that something was defamatory prior to publication or on the point of publication. It has again to be looking at the words in the abstract, and the only rule we have for looking at the words in the abstract is the common law rule about the reasonable reader and whether or not the imputations the reasonable reader would arrive at would substantially affect in an adverse manner the attitude of other people towards him. And that has to be predictable. It has to be capable of being assessed. And one would think that newspapers like the appellants would want that certainty, would want that predictability. That is what the night lawyers, the daytime lawyers on newspapers are all doing. They're all looking at the tendency of the words they're about to publish and assessing whether or not they would be actionable. If actionable, would there be a defence? Could you prove it true? Would it be a reporting privilege? Would it be a Reynolds privilege? Would it be fair comment? but they can know that it is actionable just by looking at the words prior to publication, and they can advise on that. I think that concludes what I want to, what I can extract from the Act itself. Can I now then turn to the judgment of the Court of Appeal and explain why we say that they nearly hit the mark, but they were just short of it in a few things that were said. And we have that in volume 1 of the journal. There are two misunderstandings we, with great respect to the Court of Appeals, submit. We say that they were totally correct in concluding that what Parliament had done in Section 1 by putting in serious instead of substantial was adopting the Thornton test and upgrading it from substantial to serious, and that would have the effect of eliminating a margin of actions, and that margin obviously would be in the hands of the judges giving effect to Parliament's intention. Now, where there are, we suggest, two misunderstandings. Firstly, is as to the nature of the presumption of damage, and secondly, as to the meaning of the words "is likely to," and I've already covered in detail what our submissions are on "is likely to." But as I said earlier, the rudiments of actionability at common law are that the claimant has to discharge the burden of proving the publication of the words to the third party, that they referred to him, that they were defamatory of him, applying the common law rules. And the civil burden of proof applies to all those. But once that has been proved, the burden of defending as lawful the publication falls on the defendant. So I'm just looking for the court. Where is the court of judgment?
The back of Core Bundle 1.
Okay, thanks. There are passages where the judgment doesn't quite accurately reflect the common law position, and it's that which I would like to go to, and I think one principally finds it if we go to the Court of Appeal judgment, which is tab 2 at the back, H2, and the page number I want to go to is electronic 217, 216, and 217, and that's hard copy 2829. Paragraph 70 of Lord Justice Davis, he says, if on the other hand the meaning so established conveys a serious, actually can I just start at the end, the last sentence of 69, where he says that you apply the meaning rules of Janes and News Group, and then he says, last sentence, if the meaning so established does not convey a serious defamatory imputation, then the claim may, by reason of Section 1.1, be vulnerably struck out with more ado. We say yes, it does. It has to. That is the common law upgraded Thornton plus test. If it doesn't meet that test, doesn't matter what the consequences were, it will be struck out.
I thought you were saying 40 minutes ago that striking out actually has nothing to do with actionability.
No, this would be actionability. This would be that it fails to be defamatory.
This would be an old-fashioned no cause of action strike.
Old-fashioned no cause of action.
I see.
Yes.
Not an abuse strike.
Not an abuse, no.
Yeah, I see.
No. It'd be struck out as failing to disclose a cause of action, yes. Paragraph 70, if on the other hand the meaning so established conveys a serious defamatory imputation, and that does not require cases of the extreme kind referred to in Cook, then an inference of serious reputational harm ordinarily can and should be drawn accordingly. So please note ordinarily, because we part company there. The defendant may seek to rebut or challenge the drawing of such an inference. We say no. And then the other words to highlight that we say are not correct, as he goes on, moreover, the drawing of such an inference in such a case, viz. Where the words used are assessed to be seriously defamatory, also to an extent accommodates the long acknowledged difficulties. No, it doesn't. It's irrebuttable. And then he says, at the last sentence, in this context, I also would reject possible suggestions of defendants' arguments to the effect there are no boundaries to the evidence that may be adduced to such a threshold hearing, and that evidence of reactions of individual readers, Twitter users, is necessarily called for. Now, all of that, if the Court of Appeal are correct, as we say they were, that Parliament has given statutory status to Thornton, and of course left intact and encouraged and highlighted the capacity, the jurisdiction to strike out on a Jamil basis, then an inference of serious reputational harm will, starting at the beginning of paragraph 70, if the meaning establishes a serious defamatory imputation, in other words, one in which the judge can say, publishing this to someone is going to cause serious harm to the claimant's reputation, then the presumption comes into play. It's a legal presumption. It is not a substitute for an inference. So I think the problem with using the language of inference, as the Court of Appeal does, is that it misleads you, it draws you into thinking it's something that can be rebutted, that it's something in which there can be an evidential inquiry as to liability. Evidential inquiries to damages, yes, not liability.
But the presumption has only been a presumption of damage. It hasn't been a presumption of serious reputational harm. So don't you need some other legal mechanism to get that up and running?
No, again, that is another, I think, slight misunderstanding by, sorry, not
No, please.
not yours. I mean, the Court of Appeal. It's what the Court of Appeal.
I'm sure it's mine. No, don't pussyfoot around.
No, I wasn't saying.
What's wrong with what I've just said?
Your misunderstanding. It's the Court of Appeal's misunderstanding. All one is concerned about is what is a prima facie case? If you have a prima facie case, you win at trial unless someone has a defence or you are struck out for some reason. A prima facie case is completed by a legal presumption. You do not have to go on at trial in order to prove serious reputational harm because you've got your prima facie case. That's how the common law works. That's how Thornton works. And the problem here is trying to sort of mix and match bits of things that would go into a striking out and bits that would complete the cause of action. Lawyers have to know in order to advise what are the ingredients of the cause of action, when is it complete. It is completed by the presumption of damage. It doesn't have to be a presumption. It isn't a presumption of anything more than nominal damages. It's not a presumption of substantial damages, but nominal damages at trial can still give you your vindication. That can still give you, unlock Section 12 defamation, unlock Section 13 of the Defamation Act, enables you to get an injunction. It enables you to terminate the damage that you've been caused. And
in other words, you say that the legal presumption is irrebuttable.
It is, indeed.
And
yes.
the only way in which the claim, once a prima facie case has been established, the only way in which it can be defeated is by the establishment of a viable defence.
Or that it is a Jamil abuse.
Or a Jamil abuse, yes.
And that's how the common law worked, and that is how we should work now. There is nothing to indicate if it is right that it's Thornton plus. So the passages that go on, it's paragraph 72 in, I should say, by the way, that the irrebuttable nature of the presumption was declared to be the case in Jamil, by the Court of Appeal in Jamil, and they then held up its irrebuttable nature against Article 10, and they concluded it was compatible. And no one since then has said otherwise in judicial terms. So paragraph 72, Lord Justice Gate goes on to say, a presumption, whether rebuttable or irrebuttable, arises before and irrespective of the consideration of the inference. An inference arises after and in consequence of the consideration of the evidence. Thus, at law, in cases of libel and some cases of slander, there is a presumption of damage, which presumption has, in my view, as will be gathered, not of itself been displaced by the 2013 Act, but there's no presumption at law of serious damage in a libel case. And that is potentially misleading, because he is seeming to suggest, and it's apparent throughout this part of his judgment, that he thinks there's something left to go to trial. So that if it's serious, if it's a seriously defamatory allegation, imputation, he says, well, ordinarily, any dispute about whether serious reputational harm has been caused will go to trial.
Well, that's quite a significant departure from Lord Justice Davis, is it not, on your part? I mean, you say that it doesn't matter whether it's substantial or serious, the irrebuttable presumption arises. He seems to be making a distinction between the two. He's saying that while it arose in relation to substantial, now that we've got this new rubric of serious damage, the landscape changes.
But the landscape changes by you upping the actionability criteria, not changing it, not adding a new hurdle, but by raising
I
what it
appreciate
is
that
the
that's
judge
your
is
argument,
looking for.
but that seems to me to be a significant departure, not
Not a minor departure.
not a minor departure from Lord Justice Davis.
Well, what comes from this is that he has not factored in the irrebuttable nature of the presumption.
Oh, well, not only is he not factored it in, he's disavowed it, hasn't he?
Well, I don't accept that was what his intention was. His conclusions are perfectly clear at 82, where he says...
He says there is no presumption at law of serious damage in a libel case.
Well,
it's as close to disavowal as I think I've seen.
No, the presumption isn't a presumption of serious damage. It is a presumption of some damage. It's what gets you your liability.
The presumption, you say, of all the damage he needs to have a cause of action. But that doesn't seem to be what Lord Justice Davis is saying.
No, I
He
think
seems to be saying the opposite.
he is saying the opposite there, or he's saying something different there, but it's in section 82.
Paragraph 82.
Paragraph 82. In his drawing the threads together, he is saying that the Act gave statutory status to Thornton. Now, why say that, other than to say that it is the methodology is the same for actionability? And he says, albeit also raising the threshold from one of substantiality to one of seriousness. No less, no more, but equally no more, no less. The Thornton case has thus itself been superseded by statute, not overturned. So there is no additional hurdle for actionability, for the prima facie case, for what it is that gets you home at trial, for what it is that establishes that you have suffered a wrong, because it is a wrong to publish defamatory falsehoods about people unless you have a justification in law, unless you have it's a public interest to do so, or it's a reporting privilege to do so, or it's an expression of opinion that people would recognise as an expression of opinion. There is no right to publish defamatory falsehoods. It is a wrong. And the question is, how do you get from the starting blocks to the point where you get the vindication, where the defence of justification fails, defence of truth fails, or there is no defence of truth, and you unlock the means whereby you can restore your reputation generally. That is what Thornton and Thornton Plus is about.
But Section 1.1 may not be a new hurdle, may just be a higher hurdle, but it's something that the claimant has got to confront. So can you simply explain, for my benefit, I'm sure it's my fault, if the claimant has got to deal with Section 1.1, how does he deal with it, and at what stage does he deal with it?
What the claimant has to do, we do the statement of claim test, he has to prove that a publication has taken place which, under Thornton substantially, under Section 1 seriously, alternatives, it's the raising, affects in an adverse manner the attitude of other people towards him. That is the Thornton test. The threshold of seriousness was that it cannot be, as it was at one time, that any trivial defamation was actionable.
When you say it seriously affects, don't you mean has an inherent propensity,
as in the tendency
seriously?
to, yes.
I think that's your submission.
Yes. That's the wording I took from Mr. Justice Tugendhat, who made it clear that it is about the tendency, it's the capacity of the words to cause harm. That is the tortious wrong. To publish words with that capacity, that quality, without a lawful justification, where you have to prove your justification for doing it. That is how protection of reputation is set.
Yes, it's the nature. You don't have to prove actual damage, but you have to prove that the nature of the words are such that serious damage.
That as night follows day,
yes, serious
people's
damage
attitudes
results.
will change.
Yes.
And once you've done that, you say your cause of action is complete, and there can't be any question of a preliminary issue with substantial evidence about it of the type to which Lord Justice Davis refers in subparagraph 4 of paragraph 82,
No.
I think.
Well, there could be, I suppose, if there was
I know it's an issue about whether there was in fact a publication, but I'm talking about questions about serious reputational harm.
Well, I suppose it could be about tendency, I suppose, but it doesn't really lend itself to a preliminary hearing, I wouldn't have thought.
No, it's a paper
Either
exercise.
it has a tendency or it doesn't.
Yeah, and not to evidence.
It's a paper exercise. It's done every day in the libel courts, and it might be a hearing of 2 hours. Everyone's arguing about the capacity of the words to cause serious harm to reputation. That's what tendency is about. So that is entirely correct, if I may say so, that there is nothing to have a preliminary issue trial on in actionability if the defamatory statement has the tendency to cause the requisite level of serious harm to reputation. And we see that there are points where he has referred, an example is at paragraph 80, we just have a look at this. He says, starting the second sentence, if the implication of the words used is serious, carrying with it the inference, not presumption, that serious reputational harm has been or is likely to be caused, then it is, in my view, not right for a claimant then to have to carry a further burden at an interlocutory stage. That is the same point as my Lord Briggs. That is assuming that the business of actionability may not be over yet, but that is not Thornton. Then he says, surely fairer once such a case has been properly pleaded and the defamatory meaning sufficiently grave for an inference of serious harm to be drawn, then it is for a defendant to seek to show why the claim nevertheless should not be permitted to proceed to trial, whether by making an application under CPR Part 24 or by a Jamil application. And we say yes, Jamil application, no to CPR Part 24.
Yeah. I'm right, I suppose, in assuming, am I, that post-Thornton and before the Act, the Thornton question was always addressed as part of a meaning hearing. Because the question at the meaning hearing is, well, what precisely does it mean, and is what it means defamatory?
That exercise is still being done. Mr. Price's argument isn't that you look at the publication and then see what happened in the end, what damage was caused. He says you do go through the common law methodology first, in which case, what is really the difference between his test of it's so obviously likely and what the common law is doing? The judges are saying it's obviously so likely to cause serious harm to reputation that it's defamatory.
Well, the difference surely is that his submission involves making a presumption of fact, therefore one which is potentially rebuttable, whereas yours is, by definition, irrebuttable presumption of law. And that's why the observations of the Court of Appeal at paragraphs 72 and 3 are significant, because although much of the tenor of their argument supports your position, those paragraphs appear directly to support his.
Albeit not relied on, as I understand
Well, don't mind that.
I'm the one who's drawn attention to them. If you have a so obviously likely test, you are saying that there comes a point where you can presume damage. Now, if you have a test, as the common law does, that is, the common law has decided is sufficient to ensure that only cases where substantial harm before serious harm now get through, then you don't need a so obviously likely test. So why would you have, so if in the so obviously likely test scenario of Mr. Price, presumably you'd start your claim on the basis it was so obviously likely, and the defendant come along, and the court is having to predict in exactly the same way as it does in the common law. Is it going to look at the tendency of the words and say, does this person have a good cause of action? And yet, paradoxically, the cases that he said should go through without proof of actual injury are the ones that are so obviously going to cause injury that you think bizarrely, but actually, they didn't produce any injury. Those surely are the cases where the court would be saying on his methodology, you had no consequences from this being published, so obviously it wasn't seriously harmful.
You mean no pecuniary consequences?
No pecuniary or no detriment of any kind.
Well, those are two different things, aren't they? Because I think that he has said what you predict is the gravity of the general damage.
Well, he is presupposing that some cases can proceed on an assumption as to whether damage might occur. But that's what the common law does.
It's not an assumption in this case, it's an inference.
But it's an inference. But he then, so, very well, so the position then is if you get to trial, and it may be, and no one knows whether there's a cause of action because it's got to be decided at trial. In the meantime, so you're going to have a trial of a preliminary issue, which of course is what happened on the interpretation by Mr. Justice Warby, that we had a series of preliminary issue trials. His Honour Judge Maloney's case in Theedon went on for days and everyone was cross-examined and evidence was adduced simply on actionability. At the end of which he said, I could have told you, just looking at the papers, that this was actionable, that this is serious harm.
Can I make sure I fully understand how the ordinary pre-2013 libel action would proceed? As I understand it, if the claimant wins at the meaning hearing in showing that one or more statements are defamatory, he's got a cause of action, and all that's left for trial is defences and quantum, as I understand it. You say, I take it, that Section 1 isn't introducing a new form of statutory defence, so it wouldn't fit into that category in the ordinary way. And you say, unless it's to become a wholly new large piece of expensive contested litigation in the middle of the existing essentially two-stage process, it's got to be fitted back into the cause of action stage.
No, we do not say that it provides a defence.
I'm assuming you say it doesn't. It's
Oh,
nothing
sorry,
to do with
I
defence.
thought you said yes.
I don't think anybody's suggesting that Section 1 is talking
No,
about defence.
no, sorry, I misheard. Absolutely. If you meet the serious harm test by the tendency of the words at the meaning hearing, you are home and dry.
Yes. Subject to defences.
And you will win at trial, even if you only get nominal damages, because a win at trial with nominal damages is still a value to a libel claimant. Sometimes people say, I don't want the damages. I only want nominal damages. I want the vindication. I want to push you into a case whereby you jolly well prove it's true. And if you don't, I come out at the end of it with the falsehood exposed. Gosh. So those are so that's the area in which we have that difference with Lord Justice Davis. And the reason why it matters is that certainly in the case of the two libel judges mainly sitting now, is that Mr. Justice Warby in his recent cases has taken the view that if the words are defamatory, contain a serious defamatory imputation, that there's no room for anything else to be decided at trial. Mr. Justice Nicklin appears to take the view that if the defamatory imputation is not high enough, such that it doesn't meet the seriously defamatory test, the claimant can have another go at it at trial. So whereas in the case of Mr. Justice Warby, it'd be knocked out. So there is a difference there which arises from the misreading of what the position, sorry, it's not a misreading of Lord Justice Davis, it is a taking Lord Justice Davis and thinking that he is extending actionability down to a point at trial, not actionability as it is at common law. Sorry, that's rather convoluted.
Well, if your argument is right, neither of the liable judges seems to be following the judgment of Lord Justice Davis.
No, well, I may have been wrong in relation to Mr. Justice Warby. Mr. Justice Warby says if there is no defamatory tendency to serious harm, that is it, game over. Sorry.
Yes, well, that's what you think the Lord Justice Davis should have said.
Yes.
But didn't.
No, he did say game over. Oh, no, he said it may be vulnerable to being game over. He said that at the end of paragraph 69, if the meaning so established does not convey a serious defamatory imputation. He says then the claim may be vulnerable to being struck out. And we say no, there's no cause of action. And Mr. Price also says there's no cause of action. Yeah. He wants an additional hurdle. So now then the second point is the words is likely or is likely to, and that is dealt with by Lord Justice Davis in a section which runs from paragraphs 46 to 49, where he treats the words as meaning tendency to. Now, where this possibly arises, this in a sense is what we were putting in front of Mr. Justice Warby. When we got to the Court of Appeal, we were saying, no, it's queer teaming, it's looking ahead to future publications and what's required to show a cause of action. I read out a moment ago Mr. Justice Tugendhat's formula, which is the Thornton threshold test. And I missed off some words from the end of it. And if I read it again, the Thornton test, as Mr. Justice Tugendhat put it, was a publication which substantially, we say now seriously, affects in an adverse manner the attitude of other people towards him, or has a tendency so to do. And
He combines both tests.
yes. So it may be that what Lord Justice Davis thought, and I think this would be a fair reflection of what we were canvassing in front of Mr. Justice Warby, it's not easy wording on any view, was that it was an attempt to be totally true to the formula in Thornton. But the seriously affects in Thornton, as opposed to the tendency so to do, is the tendency. It's not has affected. And that's made absolutely clear by Mr. Justice Tugendhat, as it is in all of the authorities, Simmons, Stretch, all of them, the Birkhoff and Birchill of Lord Justice Brian Neal, which was the basis of the Thornton formulation. It is not about anything other than the tendency of the words in the course of circumstances of the publication. So if we have, I think we have expressed a reservation in our case about the use of the words or has a tendency so to do, because it is duplicative, basically. It's a tautology, because words which seriously affect in an adverse manner the attitude of other people towards him are words which have that tendency, because that's how that is arrived at. So I think that Lord Justice Davis has picked up possibly that, and that is why he said, or likely to do so, should equate to a tendency to do so. And we suggest that that actually doesn't really reflect the nature of the cause of action, or that each publication is a separate cause of action. You have to look at the particular cause of action, and the cause of action, if publication has taken place, that is the cause of action. What happens later doesn't create the cause of action, because it's actionable on the point of each reader. It is actionable on the point they read the words with a tendency to cause defamatory, tendency to have a defamatory meaning. So you've got to give some purpose. One presumes one's got to give some purpose, is likely to, and there has to be a queer teamit test. And if we're right about the interpretation of section 1.1 in terms of has caused, that it's looking at the defamatory nature, quality of the words that have been published, then you have to think about, how do I get an injunction for a threatened falsehood? I would have to show something. What do I have to show? I have to show the likelihood of the harm that would have been caused if it had already been published, the likelihood of serious harm to reputation. And that would have to be done compatibly with Section 12.3 of the Human Rights Act in accordance with the test in Cream. And that is why we say we've been given something lower than Justice Davis, a likelihood, something less than more likely than not. And we say, no, it is more likely than not if you want to establish a basis for a restraint, queer teamit. And queer teamit, as I say, is being looked at all along throughout an action. If a claimant is pleading truth, there may come a point where they withdraw the plea of truth, but they're not prepared to give an undertaking not to publish. They say, no, we will continue to publish. At that point, you might well go to court, and people do go to court in mid-proceedings to say that the plea of truth has been withdrawn, that he won't give an undertaking. He says he's regards himself as free to continue to publish, he has no other defence, you should now grant an interim injunction. In fact, there would be, if there's no defence at all, it would probably be a summary judgment case with damage to be assessed. So,
Just so I've firmly got that,
yes.
you say likely to is essentially a cream holdings likelihood, is that right?
Yes.
So it's a flexible kind of likelihood,
We
as
don't.
appears to be suggested in cream holdings.
I,
Which may not always mean
Yeah,
51%.
it would be, yeah, it could be used flexibly, of course. The flexibility is there for the Friday night injunction, when the judge is saying, I haven't haven't got everybody's evidence. I want to consider this carefully on Monday morning, and so he can make an interim injunction with a degree of flexibility. The normal principle, once he's done that, of course, is that it should be more likely than not. So this is providing. Parliament has given the criteria for actionability for publications that have taken place and the criteria for actionability quia timid for publications that are threatened.
No. Do you have any further submissions to make?
Can I just, since you could invite Mr. Price to reply if I stopped now?
Yes, well, I'd ask Mr. Bustil whether he wanted to follow.
Oh, I see. Oh, yes. Well, there is.
I understand that he is proposing to follow
Well,
on
he's
section
got
1.2.
yes, on section 1.2.
Yes.
Yes.
Well, in that case, I think perhaps we'll reserve that for tomorrow. You and Mr. Bustil have 28 minutes left. You have half an hour, so we can be confident to complete our hearing well before 11:30 tomorrow.
My Lords, may I just raise one issue very briefly?
Yes.
The appellant's case was prepared on the basis that it was understood that the respondent was going to be defending the Court of Appeal's decision in its entirety. Following the receipt of the case, we put in some further written submissions just to deal with the points on is likely to. They're in the bundle. The registrar just said put them in the bundle and raise it at the hearing.
Yes.
They're in the core bundle.
Yes, we have
Yes.
it.
So I think I formally just have to ask for permission to rely
You don't have any problem about that, do you? No. Well, you've got permission. I'll sit again tomorrow at 10:30.